Hi guys, and welcome to another episode of Attorney Vlogger, Law for the Everyday Layman. Today we'll take up the rights of a buyer who has purchased personal property. Like shoes, cars, jewelry, or anything that is personal property, under an installment basis or installment plan. Okay? So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? So when we talk about personal property, again, I said it can be watches, it can be shoes, anything as long as it is not real or immovable property. When we talk about real or immovable property, we talk about lands, buildings, houses, things which cannot by their nature be moved. And when it's personal property, clothes, this necktie, watches, or any other personal property. Okay? So, the governing law on the matter, on the rights of the buyer and the remedies of the seller in case of a sale of personal property on installment basis is Article 1484, 1484 of the Civil Code of the Philippines. This is otherwise known as the Recto law. Okay? And the purpose of this Recto law or Article 1484-A is to remedy the abuses which are committed in connection with the foreclosure of chattel mortgages and to prevent a creditor or a mortgagee from seizing the mortgage property. They'll get it and then they'll buy it at the foreclosure sale at a very low price. And then they'll still file a case against the debtor or the mortgagor for the deficiency or the balance in what he has failed to pay. Okay, so this law is to prevent that practice before, where the debtor or the mortgagor or the buyer will be unduly oppressed, after he has lost the property which he has already made payments for. He's still gonna pay for it. See, so this is what this law guards against. Okay, now this law, Article 1484-A, applies only to a sale on installments. Okay, because the buyer or the mortgagee must have defaulted or failed to pay at least 2 or more installments in order for the creditor, the seller, the mortgagee to be able to avail of the remedies of rescission or foreclosure. Okay? Now, this law of Article 1484 or the Recto law, it also applies to lease of personal property with the option to buy, such as the case where a car was allowed to be leased to a certain person and then he was also given the option to buy that car after a certain number of years. This law will also apply to that scenario. Okay? But this law will not apply in the following instances. First, if the payment plan is straight payment, one payment, this law will not apply because again, it should apply only to installment payments where there are at least 2 installments. Okay? And this law will also not apply to sales or mortgages of a real property, meaning immovables, houses and lot. This will not apply. This is only for personal or movable property. Finally, this law will not apply to replevin or an action to recover personal property in the possession of another. Okay? So, the law starts off by giving the remedies of a vendor who is not paid for the purchase of that personal property. Okay? The remedies are specific performance in case the buyer fails to pay, rescission or cancellation of the contract in case the buyer fails to pay 2 or more installments, or foreclosure of the chattel mortgage in case of the buyer's failure to pay 2 or more installments. Okay? So, those are the remedies. And if you notice, I used the word or. Okay? So, those 3 remedies I mentioned are alternative. Meaning the seller, the creditor, or the mortgagee can only pick one. Okay? And he cannot choose 2 remedies or 3 remedies at the same time. It cannot be exercised simultaneously. The remedies are alternative and he can only choose one remedy. After he has chosen that remedy, wala na. If there is a deficiency, there is a balance left to be paid, no more na, subject to the rules which I will be giving later on, no? Now, there is an exception to that rule that the remedies are alternative, no? In case the seller or the creditor or the mortgagee has chosen specific performance, and then specific performance becomes impossible, then the seller, creditor, or mortgagee can still choose rescission if specific performance has become impossible. Okay? So let's talk first about specific performance. That's a remedy on the part of the seller or creditor, no? And specific performance simply means that the seller will now ask the court to compel the buyer or the mortgager to specifically perform his obligation. Meaning that the seller is asking for fulfillment, or that the buyer please pay what is remaining of the balance due on your purchase. Okay? In case of a specific performance, the seller can also recover any deficiency. Okay, because specific performance is asking for the full payment. So any deficiency can be asked for. Okay? Now, the second remedy is that of rescission. And again, rescission or cancellation of the contract can only be availed of in case the buyer fails to pay 2 or more installments. Okay? So the right of the buyer here is to say that, hey, you cannot choose rescission if you have chosen already a specific performance or foreclosure. Okay? So, again, these remedies are alternative. And when talking about rescission, no, the creditor or the seller or the mortgagee will be deemed to have chosen rescission or cancellation when he either sends notice, okay, notice of rescission to the buyer, or if he takes possession of the thing which is sold, or he files an action for rescission or cancellation before the court. No, nagkaso siya. Okay? And in case the seller, creditor, or mortgagee asks for rescission and it is granted, then the effect is the duty of mutual restitution. Meaning, the parties now have to return to each other whatever they may have received by virtue of the contract. Okay? In other words, the buyer, if he received the thing like the car, he will now have to return that car. Okay? And the seller, if he has received some installment payments, he has to return those installment payments. Okay? Except if there is a stipulation in the contract stating that the installment payments previously paid before rescission shall be forfeited. Okay, that's a valid agreement, no? In case of forfeiture, then only the buyer will have to return the car and the installments will be forfeited in favor of the buyer, okay? The only time when the clause on rescission will be considered invalid is if it is unconscionable under the circumstances. And that will depend on a factual circumstances or on a case-to-case basis. Okay? The third remedy, again, it's alternative, no? You can only choose one of the three, no? The third remedy is foreclosure of the chattel mortgage in case the buyer has failed to pay 2 or more installments. Okay? Again, what's a chattel mortgage, no? I have talked about a chattel mortgage in a separate video. If you want to learn more, please feel free to watch it so you learn more about chattel mortgage. But chattel mortgage is a contract, no, where personal property or movables are recorded in the chattel mortgage register as security for performance of an obligation. Meaning it's an accessory contract of security. In other words, the creditor can go after that contract, no, when the principal contract has been breached or has been not performed by the debtor. Okay? In case of a chattel mortgage, please remember that there can be no pactum commissorium. In other words, upon failure or breach of the principal obligation, the property cannot become the automatic property of the mortgagee or the creditor or the seller, no? It does not become automatically his. There has to be a public auction or a private one in case the parties have so agreed, no? But the general rule is that there must be a public auction where the property will be sold to the highest bidder, in which case the creditor can also bid, and that is the only time when he can legally become the owner. Okay? And before foreclosure, before the public sale, the buyer has the right to make additional payments or pay in full, no? So that he can still get back the personal property. This is what is known as the equity of redemption. Again, the period to exercise that equity of redemption is until the foreclosure sale. Okay? Because once the property or the chattel mortgage has been foreclosed and the property has been sold, then the seller cannot recover any balance or deficiency. Now take note, that rule is specific here in the Recto law or Article 1484, because the rule in chattel mortgages is different. We'll not talk about that here anymore to avoid confusion. Please just watch my video, no? But under Article 1484, if the personal property has been sold because of the foreclosure of the chattel mortgage, the creditor, mortgagee, or seller cannot recover the deficiency or the balance in case the property was sold for an amount of less than what the debtor still owes to the creditor. In other words, let's say the selling price is 100,000. The buyer was only able to pay 2 installments worth 2,000, no? So 4,000 only. There's still a deficit of 96,000, no? And then when the chattel mortgage was foreclosed, the car was sold at public auction. And at public auction, the car was only sold for 50,000 pesos. So there's still a remaining balance that is quite still big, no? In case this is the remedy that the seller or creditor or mortgagee has chosen, then he cannot get the deficiency anymore. He cannot file a case and claim, court, please give me a chance to recover the balance that was not realized at the public sale. No, he cannot do that. Okay? He cannot do that. That is expressly prohibited by the Recto law. Okay? So, also, let's say, aside from the chattel mortgage over the property, there are other securities, either, let's say, a real estate mortgage or a guarantee. For those contracts, you can also watch my videos on those, no? But in case there are other securities, the creditor, seller, mortgagee cannot go after those additional securities if he has chosen to foreclose the chattel mortgage. Why? Because if the creditor still goes after, let's say, the guarantor, and the guarantor pays the creditor, then what is the remedy of the guarantor? He'll still go after the principal debtor. Then it will be as if the debtor still paid to the creditor, no? So there is an circumvention of the law, no? It will be allowing what the law in effect prohibits, and that is not allowed. Okay? So if the creditor or seller or mortgagee chooses to foreclose on the chattel mortgage right away, he can no longer foreclose on the real estate mortgage. He can no longer go after any other guarantee, etc. Okay? So this is probably the worst remedy of the creditor. This is the last one that he should choose, no? Because he will not be entitled to the deficiency and he cannot go after the other securities. Okay? Now, please remember that if the seller assigns his credit to another person and that person now becomes the new creditor, then he is also bound by this same law. Okay? Now, the law grants us an exception, no? From the rule that the creditor cannot claim the deficiency, no. This exception is known as the perverse mortgagor buyer or perverse buyer mortgagor. In case the buyer hides the property, no, the chattel, to prevent the seller from foreclosing it, then if the seller has to file extra actions, no, to recover that property, like replevin or any other action, then the Supreme Court has held that creditor may recover the expenses which he incurred in order to recover that property in order to foreclose it. Okay? So, just to sum up, these are the remedies of the creditor: specific performance, rescission in case the buyer fails to pay 2 or more installments, or foreclosure of the chattel mortgage in case the buyer fails to pay 2 or more installments. No, these remedies are alternative. Okay, so the creditor, seller, or mortgagee can only pick one. And as for the rights of the buyer, he is protected from the greedy creditor or seller or mortgagee who, after trying to foreclose on the chattel mortgage, will try to claim the deficiency. The buyer has a right to complain and say that, wait, I am not supposed to pay the deficiency because that chattel mortgage answers for the full amount of my debt, even if there is a deficiency. Or the buyer's right is also to say that in case the creditor has chosen 2 or even all the 3 remedies, it is the buyer's right to say that, no, you are only supposed to pick one, okay? Because the law says that these remedies are alternative. You cannot choose 2 or 3, and you cannot even use them at the same time. Okay? So that's it for Article 1484 or the Recto law on the rights of the buyer and the remedies of the seller in case of a purchase of personal property on installments. Okay? So I hope you have picked up a thing or two, and I hope to see you for my next episode. Thank you. Bye.